Welcome, everybody. Welcome to today's episode of the Law of Self-Defense show. I am, of course, attorney Andrew Branca for the Law of Self-Defense. Thank you. Thank you very, very much. Sorry, I was a couple minutes late. That's how things go here. And a little bit of helmet hair today. Sorry, folks, did ride the bike into work today. It was a balmy 31 degrees this morning. So today we are gathered to talk about a trespassing case, notably in South Carolina, because South Carolina has some very interesting facets to its use of force law, unfortunate facets. But it gives us an opportunity to talk about trespass, defense of property, defense of dwelling, and to juxtapose South Carolina's, what I can only characterize it as completely inadequate statutory framework for use of force law. Contrast that with, and I just randomly selected Florida because Florida has a very well-structured statutory framework for use of force law. You may not agree with all the details of Florida law, but it's out there for you to see, which is something South Carolina does not do for much of its use of force law, unfortunately. So with that out of the way, I think it's time to go ahead and start the formal launch of today's show. Here we go. All right. So we have a trespassing case today. Is it legal to shoot trespassers? That's what we are discussing based on a case that recently occurred out of South Carolina. I'm not even going to bother checking if Rumble is streaming correctly. Hopefully it is. Hopefully it is. So let me pull up this. Before we jump into that, how can I be so remiss? I do, of course, have to mention our sponsor, which is none other than Law of Self-Defense itself, in the form of our book, The Law of Self-Defense Principles. This is your handbook to being hard to convict if you're ever compelled to use force in defense of yourself, your family, your property. Check it out on Amazon, 5-star rated, but don't buy it on Amazon. They'll charge you for the book and the shipping and handling. We only ask that you cover the cost of the shipping and handling. The book itself is free when you order it at lawofselfdefense.com/free book. And now we have a handy dandy QR code right there in the image. So I know you have your phone with you. Just go ahead, give that a quick scan. It'll take you right over to where you can get this fantastic book for free. The holiday season is here, folks. I can't promise you'll get it by Christmas at this late date. Sorry about that. But it's always a good gift for yourself and for those you love, friends and family, that you would like to be hard to convict if they're ever compelled to defend themselves. Lawofselfdefense.com/free book. All right. So let's take a look at what we have here in the form of this news report from Fox TV just a few days ago. Father and son farmers charged with killing armed trespasser. Rural South Carolina farmers charged with killing an armed trespasser were defending their land and their livestock from an uninvited intruder who arrived with a deadly weapon, according to their lawyers. Ryan Jordan Lindler, Sr., 52, and Ryan Lindler, Jr., 26, allegedly gunned down neighbor Kevin Lester Newhouse, 36, during a confrontation, according to the Lexington County Sheriff's Office. It's going to come down to property rights, vandalism, a history of trespassing, the right to defend others, said attorney Eric Bland. Eric Bland in South Carolina. I wonder if this is the same Eric Bland that spouts so much nonsense on Twitter. I bet it is. Because this doesn't look good for his clients. It seems like what Twitter Eric Bland would be talking about. We'll get back to that, I suppose. Eric Bland, whose firm Bland Richter is representing the elder Lindler. I guess the son's going to have his own lawyer. All things that property owners guard for and against. People in Lexington County, South Carolina, value their property, and a lot of citizens respect each other's property. I don't know what that's got to do with use of force law, but whatever. Both father and son intend to fight the charges vigorously, lawyer Bland said. The younger Lindler is engaged to be married in 3 weeks, Bland said, and the trespassing occurred at the home he is building with his fiancée, which is about 85% complete. I don't know what that has to do with this case. These cases will test the right of a property owner to protect their property from trespassers and vandals, including those who may bring deadly weapons onto the property of another, Bland Richter said. That's the law firm. Bland Richter said in a statement Tuesday. The sheriff said over the weekend that the elder Lindler disarmed Newhouse before telling his son to shoot him. Well, that's a little awkward for the defense. Quote, over the course of their investigation, which included interviews with both Lindlers and witnesses, detectives determined the elder Lindler told the son to shoot the victim, Lexington Sheriff Jay Kuhn said in a statement. The shooting happened after the elder Lindler had taken a machete away from the victim, who was unarmed when he was shot, and lived near the Lindlers. Newhouse tried to get into his house before the shooting, but the elder Lindler allegedly blocked him from doing so, according to court documents. The younger Lindler told police Newhouse swung the machete at him and his father, striking each of them during the altercation. I don't know if you've ever seen an injury caused by a machete, folks. I can tell you I've seen a machete buried halfway through the very thick neck of a pig with one stroke. So generally, machete injuries are pretty traumatic. But the son says that the victim here in Newhouse swung the machete at him and his father, striking each of them. That's when the son is accused of firing 3 to 4 rounds from a Glock handgun. At least one shot fatally struck Newhouse in the head. Both the handgun and a machete were recovered during a search of his truck. I hate it when they use pronouns like this. Who's his? Both men, father and son, faced murder and weapons charges and were being held without bail. They've since made bail, by the way, a couple days after this news report. Bland, whose firm represented several victims of the convicted killer and fraudster Alex Murdaugh. Oh, it is that Bland. Hey, Eric. Said the Lindlers have been longtime law-abiding citizens who grow hay and raise cattle in the rural community. Newhouse lived near their farm. Quote, their father and son, who have zero criminal background, both of them graduated from Gilbert High School. The son has had nothing ever in his background, ever, other than a speeding ticket, not even a detention at school. A great deal transpired between the alleged trespassing on the Lindlers' property and the deadly confrontation with Newhouse. Blah, blah, blah. This is a tragedy all the way around, not only Newhouse and his family, but for the Lindlers and their family. Yeah, I guess it would be, especially for the dead guy. Let's see, you've got the incident report here. Names the victim. A death occurred on December 6th. Let's see. I guess the redacted name here under other involved must be a witness. All this property is redacted. These would be mostly vehicles, I suppose. And let's see, is there anything informative here? Ryan Lindler Jr., Ryan Lindler Sr. Oh my gosh, look at these redactions. Very unhelpful. All right, here we go. Let's see. Lexington County CC, must be law enforcement, advised that they received a call saying that a male had been shot in the head and that people were fighting. I arrived on the scene, so this would have been, this is a police officer, presumably. Officer Sharp. Officer Sharp arrived on scene and went toward the back of the residence and located a male, later identified as Kevin Newhouse, lying on the ground. Deputy Brazel and Deputy Aiken were attempting life-saving measures. There were 3 females on scene, and one of them, redacted, and I escorted them off of the property. I then heard Deputy Apgar put up crime scene tape and start a crime scene log. Deputy Aiken was gathering witnesses and watching the front of the scene. The FTO ML, so that would be field training officer, had the deceased body and back of the residence cover. I then went and spoke with Ray Lindler Jr., who's the one who shot Kevin Newhouse. Ryan explained that he witnessed Kevin on his property with their cameras and came to this address with his father. Ryan Lindler, father, to confront Kevin. Ryan explained that they started talking to Kevin, but he didn't say much, but explained that Kevin grabbed a machete and started to swing at them. Ryan explained that his father was hit, and so was he. Ryan then explained that he took out his gun and shot Kevin. Ryan stated that people started to come out of the woods, so they left. Ryan explained that he also called 911 about the incident. Ryan did explain that the gun and machete were in his truck. This information was passed on to detectives. Ryan had a 6-round Glock magazine in his pocket. The magazine had 5 Venom 9P VNM rounds. Oh, good Lord. Don't don't do that, folks. And 1 Luger 9mm round. The magazine was tagged into evidence. I then called Major Crimes and advised them of the situation. I spoke with Watch Command and Region Command about the situation as well. Major Crimes, Coroner, Watch Command all arrived on scene. I was relieved by night shift. My body-worn camera was activated during this incident. That's the whole police report. And then we have the arrest warrants. Another law enforcement officer swore out an affidavit for the arrest of Ryan Lindler Sr., alleging that on December 6th at approximately 4 p.m., while in the rear of this property, which is in the Lexington area of Lexington County, South Carolina, the defendant, Ryan Jordan Lindler Sr., did with malice aforethought tell a co-defendant, his son, to shoot the victim, Kevin Lester Newhouse, after the defendant disarmed and had taken a machete away from the victim. The defendant also prevented the victim. Let's see. Sorry, folks. I forgot to switch it over. Here we go. I'm reading this this paragraph here near the top of the screen. Boy, that's hard to see, huh? Let me do this. That Ryan Jordan Lindler Sr. did with malice aforethought tell a co-defendant to shoot the victim, Kevin Lester Newhouse, after the defendant disarmed and had taken a machete away from the victim. The defendant also prevented the victim from entering his residence prior to the physical altercation. The defendant admitted post-Miranda that he and a co-defendant confronted the victim about a trespassing incident. During a physical altercation, the defendant instructed the co-defendant to shoot the unarmed victim. These facts are supported by witness statements, defendant and co-defendant statements, evidence on scene, and the incident report. And then the arrest warrant for the son who fired the shots. On December 6th at approximately 4 p.m., Ryan Lindler Jr. did, this is just the weapons charge now against the father still. He did commit the crime of possession of a weapon during a violent crime by committing the crime of murder. Murder is defined by statute 16160. While armed with a machete that was taken from the victim, Kevin Lester Newhouse, he instructed a co-defendant to shoot the unarmed victim. And now we have the son. On December 6th, 4 p.m., Ryan Jordan Lindler Jr. did with malice aforethought shoot and kill the victim, Kevin Lester Newhouse. The defendant admitted post-Miranda that he and co-defendant tracked the victim to the victim's residence and confronted him about a trespassing incident. A physical altercation took place, and the defendant fired 3 to 4 shots from his Glock semi-automatic handgun, which struck and killed the victim. The handgun was recovered after a lawful search warrant of the defendant's pickup truck. And then they'll have the weapons charge against the son, too, for being in possession of a weapon while they committed the underlying crime of murder. By the way, this represents a very different narrative, doesn't it, than the media report? The media report made it sound like what? Like this father and son confronted Newhouse, the victim, on the property of the father and son. This arrest warrant says that they observed Newhouse trespassing on their property, but then they went to Newhouse's residence to confront him. And that's where the altercation occurred. So at the time they confronted Newhouse, Newhouse was not in the moment trespassing on their property, on the Lindler property. It sounds like to me, that's going to make for a tough defense. None of this is great. And the venom ammo, folks, from the incident report, this, please don't ever do this. Don't buy, don't make use of products or services for what's intended to be lawful self-defense. That's marketed with branding that can suggest a state of malice on your part. That's crazy. Venom 9P VNM rounds. You think they really work better than whatever ammo the FBI carries or the local police department carries, their normal hollow point, their gold dots or whatever they use in their nines? No, folks, it's no better. And it just makes you look terrible. The prosecution's going to talk about this Venom ammo 1,000 times in the course of this trial. He's going to eat that up. All right. Well, I had not looked at the arrest warrants before I started the show, folks. But obviously, if they were on this other gentleman's property, on the victim's property when the confrontation occurred, then they were not using force to prevent a trespass. The trespass was over. You certainly can't use force to seek vengeance for a simple trespass. Then you'd have to believe that their force, if it was not being used in imminent defense of their own property, which it was not if they were on the victim's property, then their only justification left for them to use deadly force would be self-defense, that they were facing an imminent threat of death or serious bodily injury. And that's what they claim, right? They claim that they were attacked with a machete. They also say that the victim here somehow secured the machete. So he wasn't carrying it on his person. He secured it, struck them with it, and that's why they shot him. But the witnesses say they shot him after the victim was disarmed of the machete. Now, are we seeing anything here that would suggest that the version of the facts being presented by the father and son is consistent with the evidence? Do they have injuries caused by a machete strike? I mean, you could lose an arm from getting hit with a machete. But their lawyer, Eric Bland, doesn't describe any injuries. Nobody describes any injuries to these guys, senior and junior. Eric Bland, the lawyer, talks a lot about property. It's going to come down to property rights, vandalism, a history of trespassing. None of that has to do with self-defense. You think if his clients were attacked with a machete, he'd be talking a little bit about that as the justification for why they shot their neighbor? But the lawyer's not. Their own lawyer's talking to the media. He's talking about the son's getting married. He's building a home that's 85% complete. What's that got to do with anything? Now, granted, the lawyer, even if it's Eric Bland, the lawyer's stuck with the facts his clients give him. But if he had good facts, I expect he'd be talking about them in this news report, in this report statement he gave to the media. Now, there is a little bit of a wrinkle here in all this, in that South Carolina use of force law is terrible. I mean, it's not necessarily substantively terrible, but there's basically no statutes on self-defense, defense of persons law in South Carolina. And this is not the only state that does this. Massachusetts also has essentially no statutes on self-defense law. It can happen in these old states, the original 13 colonies states, and they've just never gotten around to codifying self-defense law. Now, they have self-defense law, of course, and it's not that different from other states. It still follows the same fundamental 5 elements of self-defense, but it's all in court decisions, in case law, in common law. It's not in statutes. So you can't just go look up the South Carolina statutes on self-defense law. Where do you find the law? Well, you'd have to go read the appellate court decisions. And of course, the appellate court decisions are distilled down into jury instructions. So you can find the South Carolina jury instruction. In fact, I think I might have pulled it up here. I did. So here's the South Carolina jury instruction on self-defense. And it's a standard type of structure for self-defense. Again, it encompasses the 5 elements of self-defense. But, finding jury instructions for states can be tricky. Statutes are just about always available on the internet. You don't need anything special. Jury instructions can be pretty tricky to find. A lot of states don't make them readily available. Texas makes you buy them for $500 a year. Thank you, Texas. Of course, as a lawyer, we have a professional legal database. We use Lexis here in my office, but so we can get the jury instructions, but it costs us thousands of dollars a year to have that Lexis account. So the law exists in South Carolina. Self-defense law exists. You just don't find it in statute. And in particular, for purposes of this discussion, South Carolina has, as near as I can tell, no law that I can find on defense of least defensible property. So let's talk a little bit about that. I have a slide deck here. This is pulled from as you know, we have state-specific courses on the use of force law of each individual state. This happens to be the South Carolina slides that we use for our South Carolina specific class. If you're interested in the specific self-defense law of your particular state, it's pretty easy to get. Just go to lawofselfdefense.com/state. I don't have it here. Or become a Law of Self-Defense Platinum member and for 82 cents a day, and get your choice of any 3 state-specific courses as part of that package. Check that out at lawofselfdefense.com/82 cents. Now, one of the things we always talk about when I teach defense of property is I caution strongly against getting involved in defense of at least personal property, least defensible property, because you're incurring a tremendous amount of legal risk. You could end up spending the rest of your life in prison. You could end up killed in the confrontation. And I generally urge people not to get into fights they don't need to get into. So if you can, consistent with your own safety, not have to get into a fight, especially a gunfight, over least defensible property, that's probably the prudent way to go. But I don't tell people what to do. I only try to help you make an informed decision. Now, when I say least defensible property, you may be wondering what I mean by that. For use of force law purposes, we can really divide property into 2 buckets: least defensible and highly defensible. And least defensible is just stuff like your cell phone, open, unimproved land, pets. Sorry, folks, with the pets, I know you feel legitimately like the pets are just as much a member of the family as the humans in your family. Maybe more than the humans in the family, I guess, depending on the humans in your family. But for use of force law purposes, they are least defensible property. Unoccupied vehicles, least defensible property. And if we're talking defense of least defensible property, you can only use non-deadly force in defense of least defensible property, except in Texas. Texas is the only state that has a provision that allows for the use of deadly force in defense of least defensible property. I still urge you not to do it even in Texas, but the exception should be noted. Texas Penal Code 9.42. But the other 49 states, if we're talking least defensible property, the only thing you can use is non-deadly force. Now, if we're talking highly defensible property, you may be privileged to use deadly force. Highly defensible property always includes your dwelling or residence. It often includes your place of work. That varies a lot by state. It often includes an occupied vehicle. And generally what the law does in the context of highly defensible property is create a legal presumption that you've met the necessary conditions for the use of deadly force in self-defense if you're dealing with a genuine intruder into that highly defensible property. For our purposes, the distinction today is between just someone's committing a simple trespass on land as opposed to someone's making a forcible entry, unlawful entry into highly defensible property. Now, back to the South Carolina. So, what statutes, jury instructions, case law was I able to find in South Carolina on the question of how much force you can use in defense of least defensible property? I can't find anything. Literally nothing. Now, they do have statutes that address the question of the use of force, particularly deadly force, in defense of highly defensible property. They adopted those statutes only in 2006, so not very long ago, but they do have those. They do have a statutory framework for the defense of highly defensible property, but I can't find anything for the defense of least defensible property. So there's no statutes that I could find. There's no case law that I could find. Now, that's kind of understandable in the sense that when we say case law, what we really mean are appellate court decisions. And there's lots of, especially lower level crimes that never are heard by the appellate courts. They're just not important enough. And if they're never heard by the appellate courts, there would be no case law created. And least defensible property, like a simple trespass on open land under South Carolina law, is a misdemeanor. The most you can serve is 30 days. And that would be in a county jail. So how many of those get appealed? I mean, probably none of them. Or you could pay a fine alternatively. So most people probably pay the fine. I think it's a couple $100. It's not a lot of money. So how many people are going to appeal that? Go through thousands of dollars to appeal that when they can just pay the $200 fine and have it over with. So no South Carolina law on defense of least defensible property, at least that I was able to find. And that's not common. Most states do have a reasonable framework for the defense of both least defensible and highly defensible property. So here we have, let's see, is this the one I wanted to do first? So Florida, for example, Florida has a statute on the use of force in defense of persons. That'll just cover the 5 elements of self-defense. That's fine. Then they have a separate statute for the use of force in defense of property. And what they're talking about here is least defensible property. How do we know? Because they have a separate statute for defense of highly defensible property. 776013, home protection. This covers highly defensible property. 776031 covers least defensible property. And you see there's 2 paragraphs here. And the first paragraph covers non-deadly force, using force except deadly force. And it says you can use force except for deadly force to defend your personal property, your least defensible property. The second paragraph covers the use of deadly force, and it says you're only justified in using deadly force to prevent a forcible felony. Well, Florida also has a statute that helpfully defines forcible felonies, but you can see these are really not property crimes. These are crimes against people. Murder, manslaughter, treason, sexual battery, carjacking, so that would be an occupied vehicle, home invasion, occupied home, robbery, burglary, arson, kidnapping, aggravated assault. So these are all people crimes. And anytime, if you have an attack against a threat against a person, it's a self-defense argument that's going to be made. Self-defense law as the legal justification for the use of force to prevent an attack on persons. If you have a threat that's only to property and there is no threat to persons, it's purely a property offense taking place, then it's a defense of property, legal defense that you would make. The moment, however, that threat to property also includes a threat to persons, now we're back to the self-defense space. Does that make sense? So we're only arguing defense of property as the legal justification for use of force if the only threat that existed was a threat to property. The moment there's a threat to persons, it's a self-defense legal justification. So, and then of course we have this other statute that I already showed you, 776013, home protection. It creates this reasonable presumption. A person is presumed to have a reasonable fear of imminent peril of death or great bodily harm when we have this unlawful and forcible entering into the highly defensible property, which Florida defines as a dwelling, residence, occupied vehicle. So that's a very nice statutory framework. South Carolina has nothing on least defensible property. It does have a series of statutes, the Protection of Persons and Property Act. I don't know why they call it that, because it's really only about defense of highly defensible property. But the Protection of Persons and Property Act, the PPPA, it's referred to, effective June 9th, 2006. And it's a collection of several statutes that talk, well, the first one provides some definitions of what's covered. The second one creates this legal presumption of reasonable fear that we've talked about before. And the third component here is a self-defense immunity statute. But none of this deals with least defensible property. So the definitions here for what's covered are dwelling, or let's see, or a conveyance, an occupied vehicle. Let's see, dwelling. Is it? Nope, nope, just a dwelling. So any place you're sleeping, a residence, defined, or vehicle, defined. So that's the definition of highly defensible property under South Carolina law. It defines great bodily injury, pretty standard definition. And then the next statute, 440, creates this legal presumption of a reasonable fear against someone who's unlawfully forcibly entering or attempting a kidnap scenario. But that's all it has. So in terms of a simple trespass or a simple interference with least defensible property, I can't find any South Carolina law on that. Now, these guys may not need to worry about that because it sounds like they went to this other dude's house. So there was no defense of their own property taking place. If you believe that there was a threat to persons against them, then it would be a self-defense justification. But Eric Bland, Twitter lawyer Eric Bland, is not talking about any threat to persons in his statement to the media about this event. And I bet he would be if any of that was at all supported by evidence other than the self-serving statements of the father and son involved in this killing. So I don't have a lot of confidence in South Carolina law enforcement generally after the Alec Murdaugh trial. But it sure looks like murder to me based on these the arrest warrant, the incident report, the statements by the lawyer to the media. I just don't see it. All right, let's take a look at the Law of Self-Defense member chat. Remember, folks, when we take questions and comments at the end of each show, we only take those questions and comments from our Law of Self-Defense members. So we don't even look at the comments on YouTube or Rumble or X. The good news is it's very easy to become a Law of Self-Defense member. It's dirt cheap. You can get a 2-week trial membership for just 99 cents at lawofselfdefense.com/trial. Enjoy this show on the live stream we put on the member dashboard where there's a chat function, and that's where I'm going to draw the questions and comments for today's show. And if you stay a member after the 2 weeks, it's still dirt cheap. It's only about 30 cents a day, less than $10 a month, folks, to be a Law of Self-Defense member. At the very least, you should try it out for 2 weeks for 99 cents. That's just not a lot of money, folks, at lawofselfdefense.com/trial. All right. Let's see what we have here. A lot of people in the member chat. Let's see. Yeah, it was cold today riding the motorcycle into work, but it's going to be 60 degrees midday, and midday is when I ride the 40 minutes down to Colorado Springs for jiu-jitsu, so that'll be a pleasant 60-degree ride, I should say. Let's see. Eric asks if I know whether or not CCW Safe will cover you if you have to defend yourself in a gun-free zone. I don't, folks. You would have to call them. They'll tell you. They've got a whole staff of customer support people, but you have to keep in mind. I like the guys at CCW Safe. I'm personally a member of CCW Safe. I think they do great work, but I don't work for them, so I don't stay completely up to date on whatever their terms of service are. Let's see. Yeah, a lot of redactions, huh? Yep, prosecutor's going to love the use of that venom round. Folks, use boring stuff for self-defense, please. If you can find out what ammo your local law enforcement agency carries, that's not a bad choice. I believe last time I looked, the FBI was using Gold Dot. That's not a bad choice. That's what I carry. Be boring. Yeah, so I did recently talk with, I met with the president of CCW Safe just last week, actually. I happened to be going through Oklahoma City. And the general message I got from him is they're continually, I would say, liberalizing their terms of service. So they're eliminating various restrictions and conditions that they've previously had. So the coverage is getting broader and broader over time. That doesn't mean there's no conditions. I mean that everybody has to have some. There's money involved, but they're getting more relaxed in those conditions. But I would call CCW safe for specific details on whatever scenario you have in mind. Let's see. Yeah, and folks, for those of you who are members in the Law Self-Defense playback, the blog version of today's show, I will embed those documents, the affidavit and the incident report. Let's see. Yeah, remember, folks, the jury is not going to know anything about guns or terminal ballistics or any of that. Their response to the use of a weapon and your choice of ammo is going to be purely emotional. Somebody mentions it might be useful. It's a very hot load, full metal jacket round. Might overpenetrate on humans, but could be desirable when hunting hogs. Hogs are pretty big. I wouldn't want to be using a 9mm, a small Glock 9mm for hunting hogs. Let's see. Yeah, Chris asks, what about the question of forcible entry for highly defensible property? If I lock my door, but my grandchild unlocks it, is a trespasser making a forcible entry? I would argue no. And I know it's tough. We all say, everyone in the tactical community says, keep your doors locked, right? If someone's going to come in unlawfully, compel them to break something to get in, that gives you the benefit of that legal presumption. That's a great place to be in terms of a legal defense if you've had to use deadly force against an intruder. But if you have other people over, kids, grandkids, they leave stuff unlocked. It's just reality. Let's see. Yeah, and these were neighbors, and there appears to have been some ongoing controversy between them, which would suggest to law enforcement that there have been a motive, a malicious motive for this shooting, independent of any legal justification. Big O asks, have you ever heard of a person being justified in shooting a mere trespasser to prevent or terminate a simple trespass? So a simple trespass, generally speaking, is someone's unlawfully present on your property, on your land, not in your house. That could, remember, once we talk about it, your dwelling or residence, a different set of rules apply. That's highly defensible property. But open, unimproved land, your front yard, your 40 acres of farm, if you have 40 acres of farm, where there's no threat to highly defensible property, and there's no reason to believe that they're there to commit some other crime, which could make it an aggravated trespass. But a simple trespass, the only thing they're doing wrong is they're unlawfully present on your property. I've never seen a case, even in Texas, where the use of deadly defensive force has been found to be legally justified. Now, are there cases where that could happen and the cops just would decide not to charge, or prosecutor would decide not to take it to trial? I suppose. I wouldn't want to be that person. I think the legal risks would be tremendous. Let's see, did I miss? Sean asks, let's see. Sean asks, what are the legalities of using less than deadly force for defense of less defensible property while armed with a deadly weapon? Are you more at risk because you entered a non-deadly confrontation knowing it had the potential to escalate? Well, you carrying a weapon on you doesn't change the legal standard. But of course, it does mean, as a practical matter, that if things do escalate, you may end up using that gun, right? If we're talking having a gun on you. And anytime you get into a confrontation, you have no control over how it escalates, right? That's up to the other person. It's why I discourage people from using even non-deadly force in defense of least defensible property. Because if it does escalate, so say someone you're at a Starbucks on your laptop and somebody walks up and grabs your laptop and they start walking off with it. Laptop is least defensible property. Are you allowed to use non-deadly force to prevent the taking, the tortious interference, the criminal mischief of the taking of your laptop? Sure, you can. You can use non-deadly force to prevent the taking of your laptop. What if that person then presents as a deadly force threat in response to your use of lawful non-deadly force? Well, if they actually present as a deadly force threat, in theory, now you're privileged to use deadly force in defense of yourself, not in defense of the laptop, but in defense of yourself, against their unlawful escalation to deadly force against persons. The trouble is, everyone evaluating your use of force afterwards, the police, the prosecutor, the judge, the jury, none of them are watching this. None of them know from personal knowledge what actually happened. And what if the person who took your laptop, what if they got 12 friends there who are going to tell a very different story? Then what? Then what are these? Then does the prosecutor then have building blocks of evidence? And evidence doesn't mean it's true, folks. It just means it's claims about what happened. Does the prosecutor now have building blocks of evidence from which they could build a case against you and maybe sell it to a jury and maybe get you convicted of murder and put it in a cage for the rest of your life over a laptop? Now, I'm not telling you not to use force to keep your laptop from taking. I get it. But make an informed decision. Maybe have some non-deadly means of defensive force. So you're perhaps less likely to be compelled to go to your gun. Pepper spray, maybe. Let's see. Jared says, it's scary how many people don't understand self-defense law. I'm going to give a friend my copy of the Law of Self-Defense Principles as soon as I'm done reading it. Jared, don't do that. What's wrong with you? I thought you were my friend. Jared, lawofselfdefense.com/free book. Free book. Send them to the free book. Where is it? Send them here, Jared. You keep your copy. You should be keeping it. It's not a read it once type of book. You should have it on your nightstand and every night read a couple pages, flip the book open at some random spot, refresh your recollection. Have your buddy get his own copy that he can put notes in, that he can have on his nightstand or the bathroom or wherever. lawofselfdefense.com/free book. Let's see. All right. I think that's all the questions from the chat today. So with that out of the way, reasonably, well, still 45 minutes. Good Lord. All right. So folks, that's how we're going to wrap up things for today. Remember, if you carry a gun, so you're hard to kill. If you carry a knife, so you're hard to kill. If you carry pepper spray, so you're hard to kill. If you study jujitsu, so you're hard to kill. So your family is hard to kill. I do all those things so that me and my family are hard to kill. Then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.